Please, Your Lordship, there are two applications before the court. The first is our application to adduce evidence in respect of losses up to the date of trial, and that is issued in accordance with paragraph 8 of the court's order of 28th of October. And the second is the defendant's application, firstly to dismiss our application and also to strike out much, but as I understand it, not all, of the quantum evidence that's been put in by us. And I should mention there's also been one quite troubling, very recent development, which is that the first defendant, Mr. Brindle's client, we've recently learned has deregistered from the DFSA, and we have sought in correspondence assurances and confirmations about that this won't lead to a dissipation of assets pending my Lord's judgments. We haven't yet had that. I'm going to pursue that again with my learned friend, and absent a voluntary undertaking, we may be seeking relief at the end of the day from this court, if my Lord will permit us to make that application.
But I don't have that application in front of me at the moment.
My Lord, no, we're drawing it up now.
This is an application in the nature of a freezing order.
It's essentially a post-judgment freezing order, yes.
Mr. Hill, can I invite your help with a little housekeeping? I have 13 files. They are all, I think, Altamini bundles. This represents 2 out of 7 large cardboard boxes which is delivered to the registry. Do I need more than 13 bundles in order to deal with today's application?
There's a 14th bundle, which I don't know what it is myself.
Well, we'll see if we can you see if you can find the 14. Bundle 14, I think I like you. We'll see if you can find
There's
it.
apparently a bundle 14, my Lord.
Thank you. The second matter is this: looking at the 2 application notices, the defendant's application is to exclude all your evidence. There seems to me to be some logic in dealing with that application before dealing with your application to admit the Al-Shamji second statement. Has any thought been given to that?
Well, my Lord, I had thought of that, but
It's just rather silly. It seems to me it may be a bit of a waste of time to address the question whether to admit your second Al-Shamji statement if I'm then going to be persuaded to reject all evidence.
well, my Lord, I think it's not a waste of time in this sense. The objections taken to the rest of our evidence are the same types of objection as are taken in opposition to our application to let the evidence in.
Well, I appreciate that this is a case where the word processor seems to have been allowed to take its own course, because I get the same submissions repetitively about every other page.
My Lord, I take my Lord's criticism. The same points are made in relation to both. I'm just going to go through the heads of loss once. My learned friend said that I should go first, and so I'm going to deal with his application and my application.
If that's,
and
what,
won't be repetition.
if that's what the parties think is the most convenient, then I'm content with that.
I'm grateful, my Lord. Now, before dealing with the applications, if I could just explain to my Lord where we are in terms of the quantum evidence and what the heads of loss are, and if I could invite my Lord to take up paragraph 22 of my skeleton argument, which has a table on it. Now, the first head of loss at line A of that table comprised losses on the Sarasin investments. Now, that's the 10 million odd that my Lord has already ordered, and after a delay and after we had to issue winding up proceedings, has eventually been paid. So we're not at all concerned with that today or at the quantum determination. The next head of loss was the fees and interest charged by Bank Sarasin, and my Lord may recall that was the second of the 3 categories recorded in the judgment as being outstanding for finalisation. and that is, again, not the subject of anything today, and that is because we rely on the first Griffin's report and now a supplemental Griffin's report. That has been answered by a KPMG report, which is in the bundles at tab 12, and so the evidence is all in on both sides, and it's common ground that whatever happens today, the quantum determination is going to finalise that category. So that's not outstanding for today.
You say that Head B is not up for discussion today.
Exactly, my lord. Now, Head C comprises the fees and interest in relation to the ABK lending. Now, this is a little more complicated, and if I could hand up a table in which I've essentially expanded this table to try and encapsulate exactly where the parties are in relation to all the issues. Because I thought otherwise it was getting quite confusing from the rounds of evidence and skeletons.
Does this replace paragraph 22?
It expands on paragraph 22.
Do I need both of them?
Well, my lord, no. If paragraph 22 is only helpful now in that it gives it on one page if one wants a bird's eye view. This is, of course, a 5-page table. And what we've done in this
Mr.
table...
Black had one of these?
Sorry, I didn't hear that.
Mr. Black, do you have a document which has just been handed up to me, which is headed Summary of Claimants, Head of Loss and Position of the Parties in respect of each?
Never, Lord, I have to admit I forgot, Mr. Black.
It runs to 7 pages. You haven't got a copy of it?
We will get that emailed now, so Mr. Black can have that. What we've done in this table, my lord, is we've essentially added 3 columns. The first column we've added is to confirm whether or not any particular category of loss is the subject of our application to adduce evidence. So just that's the subject of claimant's application. The next column just summarises what the claimant's position is, so the defendant's position is on our evidence. And then the last column summarises our answer. And as my lord will see, we've dealt with lines A and B where there's no objection, and we're now on to line C, where essentially this fees and interest in relation to ABK lending breaks down into 4 elements, and I'll go through them in turn. First, over the page, is the element my lord is already familiar with from the trial, which is interest up to 14th of December 2009, and that was covered in the first Griffin's report at trial, and that falls into the same category as the line B losses, in that there's been an exchange of evidence in terms of the defendant's KPMG report and our response of Griffin's report. That is going for the quantum determination. There's no objection to that and no issue for today. The next item is interest from December 2009 to trial, and that is the first item which is part of the subject of our application, because of course that is a pre-trial loss which we are now seeking to introduce evidence in respect of. And I'll come back to that in the context of my application. The third element over the page is interest from trial to essentially date, to recalculate it to the 18th of September 2014. Now that is a category which in our submission does not require the court's permission because it's a continuation of our losses in relation to ABK lending after trial, so it couldn't have been in the evidence at trial. And we would submit that that's a natural category that was contemplated by my Lord's order as being part of our updating evidence, but that is objected to, and that's part of their strikeout application. So I'll come back to that in the context of the strikeout application. The next element at C4 is a further aspect of our ABK losses, which is a relatively small claim of 700,000 odd for the essentially for the cost of funding in respect of cash inflows into ABK. This is not so much, although it's dealt with in the supplemental Griffin's report, this isn't so much evidence in the sense as our calculation of an assumed cost of funding. That is also objected to, and I'll deal with that in the context of a strikeout. And then we then come on to two new heads of loss. The first is what we've called line D on page 6, which is interest charged by CBK on the facility, which is essentially refinancing the ABK lending. And our case is that if we're entitled to our ABK losses, we're also entitled to our losses in respect to the cost of refinancing, the interest costs of refinancing. We accept that that is a loss that predates the trial and therefore needs to be the subject of the application, and that is the second of the two subjects of the application, which again I'll come back to. And the last item, page 7, is losses in relation to the sale of property as an undervalue. Now those also post-date the trial, because it concerns the sale of a piece of real estate after the trial at what we say was an undervalue, and then the collection of a shortfall on a personal guarantee, and that is the last subject of the strikeout application. So that's what all the heads of loss are, and the context in which they're objected to. My Lord may have just seen
the matters that are the subject of your application.
Yes.
Are C2, D and E, is that right?
No, C2.
C2.
And D.
D.
But not E. E is post-trial. And therefore...
post-trial. So, I thought you said there were 3 matters subject to your application.
No, my Lord, 2.
Just 2?
Yes.
C2
yes, and D.
And D are the only 2 matters in which you say you need to have leave.
My Lord, yes. There is an argument we accept about one other area, and that was C3. Sorry, C4, because on any view that cost of funding did predate the trial. Our point there is really that we're not actually seeking to introduce evidence in relation to that. What we're doing is saying this cost of funding...
If you're not seeking to introduce evidence, then it's not a matter that arises on your application.
Well, that's our point, my Lord, yes.
Well, no, I mean, whether you can rely on it or not is a matter for the quantum determinant.
Exactly, that's exactly my point.
What I'm concerned about at the moment is what your application to reduce evidence relates to.
Yes, and it is
just C2 and D.
Yes, that's correct.
What the position is on the other ones, I will hear from Mr. Brindle when he applies to strike out everything.
No, yes.
Or if I dare strike it out, I shall hear it on the quantum application.
No, yes.
Mr. Brindle, you've got a copy of this summary sheet, have you?
I do, my Lord. So if I could come now to the points on these 2 points on our application, dealing first with C2.
Could we start by looking at the order that I made
My Lord, yes.
in October?
Yes. It's in the bundles at tab 36.
Which bundle?
Well, I'm afraid mine is not split
Bundle
into...
12, I hope.
I'm grateful.
Bundle 12?
I'm afraid we, on our side of the court, receive these bundles as tabs, and we don't know which bundle goes in which. So tab 36, my Lord, picking up the order at paragraph 3, little 3A dealt with the then quantified losses, which are at head A on my table and not subject to today. And then little b, 3b, directed that further amounts were to be assessed in respect of other fees and interest charged by the second defendant, and that's obviously head B, and then losses arising out of the claimant's relationship with Al Ali Bank Kuwait. And we in fact suggest that all of our heads C and D and E fall within losses arising out of the claimant's relationship with Al Ali Bank Kuwait. That was against the first defendant, and then you get the same formulation of paragraph 5 in relation to the second defendant. And then paragraph 7 directed that all of the claims for quantification, together with any other claims under Article 42, was adjourned to the quantum determination. And then paragraph 8 contained the direction for evidence by us, and then the limitation that the evidence had to be limited to evidence of events which have occurred since 10th of July 2013, being the last day of trial in these proceedings.
So that's the framework.
That's the framework, yes. So against that background, I'll start with my category C2, which is the first subject of my application.
Your application is, there is a complaint that you provided a witness statement instead of a draft witness statement. I don't know how much mileage is going to be made of that.
No, I wasn't going to take any time.
What you would put in, if you had produced a draft witness statement instead of a signed one, it would be the second witness statement to Mr. Al-Shamji, is that right?
So I didn't. Yes. Yes.
But that is all you're asking for. I'm now looking at your application of the 20th of November.
Yes.
Which is in my documents, volume 1.
Tab 1.
Tab 1. And can you take me to Mr. Al-Shamji?
Yes.
Second witness statement.
Yes, that's at the second witness statement is in, I think, probably tab 8.
Bundle 8.
Which is in your bundle 3, I'm told, my lord. And the two categories.
This is what you want. We'll treat this for the moment until Mr. Brindle explains to me why I can't, as if this were the draft evidence for which you needed permission.
My lord, yes. But it is worth just noting.
If he insists, I shall have to direct you to withdraw this and replace it by an unsigned document of the draft.
Well, yes. That's right. It is just worth...
Maybe he has better points than that.
He might. We'll see, my lord. We suggest he doesn't. It is worth noting that this witness statement deals with the two categories at 7 to 9 in relation to the ABK interest and 10 to 13 in relation to the CBK point. Both of those do cross-refer to his first witness statement and to the Grant Thornton report attached to the first witness statement. So while this is the evidence, there is a degree of cross-reference within that.
Mr. Al-Shamji, who is instructing you now,
Lord, yes,
is not speaking from his personal knowledge about anything, as I understand it.
Well, no, he's a lawyer.
He's exhibiting some documents.
Yes, exactly. He is a lawyer, and he's certainly exhibiting a Grant Thornton report. There are some underlying documents as well.
So just show me what it is that this is evidence of.
Well, my lord, in relation to ABK, ABK interest, it's a reference to his first witness statement and then the Grant Thornton report attached. The interest that we claim is an interest that we couldn't calculate at the time of the trial because it's interest that we didn't have the bank statements, and what we've relied on is a later document which is a Kuwaiti certificate which demonstrates what the interest is, and that is also introduced in this evidence.
Well, is it? And paragraph 7 tells me that the Ministry of Justice imposed an order stipulating liability for interest.
My lord, yes.
But he has dealt with that in his first witness statement.
Yes, and that's the cross-reference that I referred to, because the way we structured our evidence is that Mr. Al-Shamsi, we put in a first witness statement to Mr. Al-Shamsi which summarised all these losses, and then what this witness statement does is, for the purposes of this application, picks out those losses that we accept need to be the subject of this application.
Yeah. So in paragraph 7,
yes,
it doesn't actually exhibit this certificate, but that's to be found somewhere else.
well, yes, and I do apologise if that's unhelpful. Then we certainly apologise for that. What we've sought to do is cross-refer to the first witness statement where that point is made and then the document is exhibited.
Yeah. What new evidence do I get out of paragraph 7?
Well, my lord,
One thing I don't get is the certificate.
No, my lord.
I get a reference to the fact that the certificate's somewhere else.
Yes, well,
Are you asking for leave to introduce as evidence the certificate of the Ministry of Justice?
My lord, yes, we are.
Yes. And somehow I meant to get that out of paragraph 7.
Yes, I do apologise. The way it's been done is by this cross-referencing system. So essentially we put in the evidence on the first witness statement. We attached a Grant Thornton report which itself had various exhibits, and then we sought to isolate what those were by referring to them all in a separate witness statement so that one could see in the separate witness statement which parts of it.
Where do I find the certificate?
It's in Bunt. One place to find this is in tab 18, which is in my Lord's bundle 8. Page 882. So bundle page 2958.
Which volume is it? Volume 8?
Well, it'd be either 8 or 9, but we don't have the volume numbers. We were never given them. We've only got
Volume 8 is tab 18, is that what you want me to
but it may run into your volume 9, and it's page page 2958 of the bundle. Volume 10. I'm grateful. Volume 10, page 2958.
Parties had actually put their heads together in order to work out what was the most inconvenient way of presenting documents to the court. They could hardly have come up with a better solution.
Well, we certainly apologise for our part in that.
Well, they're not your bundles. We don't have any bundles from you. 2958.
2958.
Well, that is, in fact, the translation of 2959.
Yes, well, yes.
I assume. Is that what it is?
Yes, that's as I understand it, yes.
So the first area of dispute is whether you will be allowed to take the court to that document in the course of the quantum hearing.
Essentially, yes. That's what we rely on for this claim.
Now, two points at least arise on that. Is it agreed that 2959 is in fact a certificate of the Ministry of Justice? And if not, how are you going to prove it?
Well, we don't have a response by way of evidence from my learned friends on this, so I don't know whether it's going to be agreed, assuming I'm successful in this application. Their position is that they will respond to our evidence once it's in. So I don't know if it is agreed. It certainly ought to be agreed. We've had this looked at by Kuwaiti lawyers. There's no problem with it, and it's a.
Mr. Hill, this application is opposed root and branch, and you can expect every possible point, good, bad, and indifferent, to be taken.
If a bad point is taken,
The first point is that if one looks at paragraph 7 of Mr. Al-Shamsi's second witness statement, it does not, in fact, prove that 2959 is a document issued by the Ministry of Justice. In ordinary litigation, one might not expect that to be contentious, but you must assume that it is.
Well,
and if it is, what is it that you rely on to prove that this document is what you say it is?
Well, we don't know yet that that is contentious because we haven't had their response. If it is, then we will have to adduce further evidence by way of reply to prove this, in particular from Kuwaiti lawyers explaining how we already have had advice from Kuwaiti lawyers explaining how this document works and what it is.
And the second point is that unless it's agreed, 2958 is not proved to be a translation of 2959. So you would have to produce the translator.
Well, yes.
So
yes.
That
if a point's taken on the translation, then we will have to produce a translator and produce evidence from a translator, if a point's taken. But we haven't got to the stage yet of knowing whether that point was taken, but I certainly accept my Lord's point that all sorts of points are taken in this case.
Anyway, that's the first point. You just want to get that document before the court.
At this stage, my Lord, yes.
And make what you can of it.
At this stage, my Lord, yes. And I accept, subject to what points are taken in response of evidence, when we get to that stage, we may have to supplement it in reply evidence to deal with any silly points that are taken about Ministry of Justice documents not being what they say, and so on.
Well, that's the first document. The second document then is the Grant Thornton report. Again, that is attached to the first witness statement.
My Lord, yes.
So what does paragraph 8 simply says that It's not evidence of anything, is it?
Well, my lord, what Grant Thornton did, and in fact what Griffins have now done in their supplemental report, which to the extent necessary I also seek to bring in, because that was put in by way of reply, is they've essentially just done a calculation.
I don't want to know about Griffins or anything else at the moment. I just want to know what it is that paragraph 8 of this witness statement is said to be evidence of.
Well, my lord, it's not evidence. This is
it's not evidence.
This is just describing the arithmetical exercise that Grant Thornton did and that Griffins have now supplemented. So the way our case works is we rely on this certificate. We have used accountants to do the arithmetic. We could have done the arithmetic ourselves, but it's easier to get accountants to do it, and that's the way we've done it. That's not put in as expert evidence so much as a useful presentation of the arithmetic. It's a presentation we submit or put in to accompany our written submissions. We've put it in to accompany our evidence.
Well, you could have done all sorts of things, but what you have actually done is make an application under the order which I made in October.
Well, yes.
And that application was for leave to rely on evidence of pre-trial matters. Right?
Yes, my lord. Yes.
So where do I find in this Al-Shamji 2 evidence of pre-trial matters? Evidence.
Well, my lord,
not argument,
yes.
Evidence.
Yes, the only evidence that we rely on, and we need to rely on, is the certificate.
Is
the certificate which my lord has been to. The certificate demonstrates the interest payable. Now,
so under the heading, losses relating to interest and charges imposed by ABK, the only evidence that you rely on is the certificate.
Well, that's the only, if you like, real evidence. We have done a calculation.
But I'm not interested in unreal evidence.
Well, this evidence is in quite raw form.
What you like by way of argument, subject to Mr. Brendel convincing me that it's not relevant. But the restriction on evidence is not a restriction on argument or submissions.
Well,
what I'm looking for is what it is you need to prove at the quantum hearing for which you need evidence of pre-trial matters.
Well, my lord, I can see a debate about what the status is of our accountant's calculations. In my submission, they are not evidence, they're only essentially assistance to submission. But I can see there's a debate to be had about that, and it could be said that the arithmetic is something that should be put in by way of evidence. Now, assuming that's the case, we have put in the arithmetic as evidence in the reports that we've submitted. We certainly say it's not expert evidence, because this isn't a recognised field of expertise on which the court needs that kind of assistance. It's assistance with the arithmetic. We have put it in as evidence. If the view is taken that that kind of arithmetic does need to be in evidence, there it is, and we seek permission for it. If the view is taken it could all just be bolted onto a skeleton argument, then we don't need to take trouble over any of these reports today.
Well, it's only, the evidence is only relevant if you want me to pay attention to the fact that Grant Thornton added up a column of figures.
Yes.
And arrived at a result. Now, it seems to me at the moment that it may be very convenient if the parties can agree that the sum or aggregate of a column of figures is in fact the figure at the bottom. But if they can't agree that, then at the end of the day, we'll all have to sit down with our calculators in court and do it for ourselves. I've tried to explain this on a number of occasions, but I suspect without any success. that it's not a matter of expert evidence as to what the aggregate of a column of figures is. It's a matter of fact. And it may be helpful to have the accountants do the sums so the parties can agree them. But the fact that the accountants have done the sums doesn't actually make the figure at the bottom of the column right or correct in its own right. It's merely their arithmetical calculation. The fact that they've been through a number of bank statements and pulled out the interest charges and then added them up is of the same kind. It's something we can all do for ourselves if we have the material which they have.
But we certainly endorse that.
So what is it you want evidence about?
Well,
the fact that they've done the calculation.
Well, we accept we could have put. Well, our position is we could have put in these reports along with our written submissions, and in a sense, it was helpful. We hoped to the defendants to put these reports in together with our evidence, but we entirely agree with my lord. The actual underlying evidence is a certificate, and the rest is calculation. And that calculation shouldn't need the permission of the court, but certainly shouldn't be ruled out.
Well, at the moment, it seems to me that if this is a head of damage or head of loss that I'm going to investigate, I cannot prevent you from putting before the court a column of a schedule which shows how you get there. Now, I don't think at the moment that it helps me very much to know whether that schedule was prepared by you or Grant Thornton or by anybody else. I have to look at the schedule and see whether it proves what you want to prove. But paragraph 9 doesn't seem to help me at the moment. Anyway, that's you want to rely on the Grant Thornton report.
Well, my lord, as now actually replaced by the Griffin's calculations, because they've redone the calculations in the.
So you actually don't want to rely on paragraph 9 at all?
Well, I think the numbers turn out to be more or less the same, but we now rely on, for this head, we now rely on the Griffin supplemental report.
So what is the point in my giving you permission to put in an affidavit which has paragraph 9 in it if you don't want to rely on it? Because you want to rely on something else, which you rely on because you produce a document as part of your argument.
Well, my lord, the thrust of what we seek is to introduce this claim by reference to this certificate. I certainly take my lord's criticism that paragraph has become superseded now because we have produced.
It's not a criticism; it's an inquiry. A lot of very expensive people who come and spend a day dealing with this in order to discover what new evidence or evidence of pre-trial events you want to rely on. And that's what I've got to decide. I haven't got to decide whether you can put in evidence of pre-trial events which you don't want to rely on.
Oh yes, the evidence that matters is the certificate.
Yeah. Well, at the moment,
the rest
the certificate, the Ministry of Justice certificate, which is, in fact, I think, itself a post-trial document, isn't it?
It is, my lord. It's a post-trial document. My lord may recall that we didn't have these the bank statements for ABK at the date of trial, and so we still don't have all the bank statements we need. They're still missing bank statements. So the only way in which we can present and calculate and prove these losses is by reference to this quite convenient certificate, which actually says what the interest was for the relevant period.
Yeah, but Mr. Hill, if page 2958 of bundle 10 is of any use to you, and I express no view about that, but if it is of any use to you, it is in fact a post-trial document.
Well, yes, but it is but it does relate to pre-trial events. So I suppose I take my Lord's point that perhaps this falls outside paragraph 8 of the order.
It may relate to pre-trial events, but it's not evidence of pre-trial events. The only evidence of the 2958 it tells me is that, or 2959 before translated. All that is evidence that the Ministry of Justice issued a certificate. And that's a post-trial event.
Right, I see that way of looking at it, my Lord. In which
whether
case,
the certificate helps you or not is a matter for further argument, but it's not evidence of pre-trial event.
I see that, my Lord. In which case one could say that this falls outside what's required by my application and then falls into my learned friend's strikeout application. But the same points arise on both, so perhaps I could summarise my learned friend's objections and our answers to those.
Well, I shouldn't even try to do that. I think we'll wait and hear what the objections are. What I want to know is what your application is.
Well, my application is to adduce this evidence in terms of...
Can we move on to 10 to 13 now?
Lord, yes. 10 to 13, these are...
Is there anything else you want to tell me about 7 to 9?
Well, I thought it might be... I'm obviously in my Lord's hands, but I thought it might be convenient to just deal with the objections that are taken. Just because then I can then do that in relation to each head of loss. I can then sit down and my Lord will have my points and my learned friend's points in one go, rather, which I thought might accelerate matters.
Well, I think I'd rather hear you on the rest of your application.
Very well, Lord.
You'll have an opportunity to reply to Mr. Brinkman's points in due course.
Well, the next heading is the CBK interest and charges. Now, we accept a new category of loss in that it wasn't raised at trial at all, and it relates to interest and charges imposed by CBK, who were the replacement financiers following a refinancing of some of the ABK lending. And
well, what you will have to do, either now or at the quantum determination, is to persuade me that this is a loss arising out of relationships with ABK.
oh yes,
Because unless it is, you get it under the umbrella of my order.
yes.
Is this a loss arising out of relationships with ABK?
My Lord, yes, because it's the loss from refinancing the very same lender.
Well, that's the argument.
Yes, that's the argument, yes.
So that's the threshold you have to cross. If you cross that threshold, then the question is, how much is the loss?
My Lord, yes.
And what does 10, 11, 12, 13 tell us about any of those things? It says, 10 says, the first and second claimants settled their liabilities on their own alone accounts with ABK. The settlement amount was 10.8 million Kuwaiti dollars funded by a loan. Now that is not, as it seems to me at the moment, that's not actually something that Mr. Al-Shamji can speak to of his own knowledge.
My Lord, no. Mr. Al-Shamsi does refer to paragraph 13 of his previous witness statement. That's the first witness.
Where do we find that?
That's at tab 6.
Which is in yet another bundle. Presumably bundle 2.
Tab 6, my lord, is in your first bundle.
First. And paragraph 13. Well, it's simply a repetition of it, isn't it?
And then, so the last evidential reference I was going to give is in Mr. Khorafi, who, of course, is a witness, a direct witness of fact, and that's at tab 16.
Yeah, but you're not seeking to put in. Your application doesn't cover Mr. Khorafi, does it?
Well, we have a timing difficulty in that we had to make our application.
Yeah.
We then had the responses in December from a load of friends. In response to that, we have put in more material.
Yeah. Mr. Hill, I'm dealing with the application I've got. And if I look at the application I've got, I don't find any reference to that David and Mr. Khorafi.
Well, my lord, in that case, I'm applying now to amend my application to include the evidence we put in response to my learned friends' objections, which deal with the same area.
Is this the first time you've sought to amend this application?
I think it is, my lord, yes.
We'll leave aside your application to amend, and at the moment, I'm dealing with the application I've got in front of me.
Yes.
And the application which I've got in front of me does not contain first-hand evidence of the settlement of the liabilities.
My lord, that is correct.
And in order to be acceptable evidence, it would have to say, at the very least, as it seems to me, I am informed by Mr. Khorafi or Mrs. Rafed or whoever that. Because if it said that, then the defendants would be in a position to serve on your hearsay notice. If they did serve on your hearsay notice, saying you've got to provide evidence from Mr. Khorafi, you would then say, well, here it is. Yes. But that's the way it's got to work.
Well, yes, I accept that. It certainly should.
What is paragraph 10 evidence of?
Yes, it certainly should. It certainly should have said he was informed by his clients.
Well, if it's hearsay, it has to identify the source of the hearsay to be of any value to anybody. And it doesn't. It really is a most extraordinary way to go about it, but that's the way it is. Let's look at paragraph 11. The claimant's case is, well, that's hardly evidence, that's simply assertion, isn't it? I mean, that's submission, that's not what evidence. I don't need evidence to what the claimant's case is. 12. The claimant's claim total interest on that loan. Well, that relates to interest charges. So that tells me the claimants quantify the loss arising out of the CBK claim is, but it doesn't in paragraph 12 tell me how you get there. Paragraph 13 tells me that that's in the Grant Thornton report. Is this another case where you don't actually rely on the Grant Thornton report, but you rely on some subsequent report?
No, but we rely on the Grant Thornton report. That's been supplemented by a further Grant Thornton report. If my Lord has the table, page 6 of the table I handed up, I've listed there the evidence we seek to rely on, which refers both to Mr. Khorafi, but it also refers to a supplemental Grant Thornton report. And I do apply to formally amend my application if I need to, because I accept that when we put the application in, we haven't put in this further evidence in response to my learned friend's complaints. But obviously this evidence all goes to the same topic, and our application is to adduce not only the original evidence we had, but also the supplementing evidence we've had, which does include direct evidence from Mr. Khorafi, and also, to the extent this is evidence rather than calculation, and really it's calculation, a supplemental calculation from Grant Thornton. Could I invite my Lord to look at what Mr. Khorafi does say, which is of tab 16, which is in bundle 6.
I've got that.
So Mr. Khorafi confirms the description previously given by Mr. Al-Shamsi in his 2 witness statements.
Where?
This is paragraph 6. Paragraph 7 to 9, he introduces the supplemental Grant Thornton report, which is the revised calculation based on bank statements. And those are bank statements exhibited to the supplemental Grant Thornton report.
Well, I'm likely to take the view that Grant Thornton's report is not going to be of any assistance to the court unless the court and the defendants can see the material which underlies the Grant Thornton report. And if that material is challenged, they have an opportunity to challenge it. And unless it's agreed that Grant Thornton saw all the relevant material and this is a summary of it, the fact that Grant Thornton writes a report saying this is what we've done isn't much help.
No, but I accept that they have exhibited what they rely on.
They've exhibited?
Yes, exactly. It's all in the bundle.
Bank statements are exhibited.
It's actually in the bundle at tab 17. There's a great big pile of statements and so on.
Unless it's tab 17. like bank statements. Or perhaps there's another bit, there's another fund. It's actually in bundle 7, volume 7.
So there's an appendix E to that Grant Thornton report, F to that Grant Thornton report, which is CBK statements. Starts at page 1941 of the bundle. So I certainly accept that if Grant Thornton were referring to material that isn't exhibited, then it's not doesn't help. But they have exhibited the material they rely on. And so the evidence that we rely on for this application is that listed at page 6 of my table. It is the original al-Shamsi evidence, as, if you like, verified by Mr. al-Khorafi in paragraphs 6 to 10, and also the Grant Thornton reports and their exhibits, which produce the underlying material. Yes. And just to give my Lord an example, at tab 17, which is Mr. al-Khorafi's exhibit, at page 1936-3, Grant Thornton, this is Grant Thornton's explanation of their calculation, which itself has as the appendices the underlying documents, and Mr. al-Khorafi has exhibited these appendices, and in doing that exhibited the underlying documents.
How do you propose to prove that the documents on which Grant Thornton have relied are what they say they are, if it's in dispute?
Well, it's hard, even by the standards of the defendants in this case, it's hard to see what dispute there's going to be about a bank statement saying what it says. If there really is, there's a suggestion that we've been forging the bank statements or something.
My experience of this case so far is that, first of all, the defendants are not themselves terribly particular about whether documents which they produce say what they say, but secondly, that they're very likely to challenge anything that they think may be of them to their advantage. And they're entitled to do that, and you should accept that.
Well, again, that really doesn't arise now, because the sequence will be, my Lord will or will not let this material in. If it's in, the defendants will answer it, or seek to. If they take what I would suggest would be absurd points with regard to whether documents are genuine or forged or something, then we will have to deal with that there and then. But we don't know that they're taking any points of that kind now.
Well, what I would be likely to do is to treat Mr. al-Shamsi too as a draft, and to require him to specify where the information, what is the source of the information on which he relies. And that would require him to say, I have been informed by Mr. al-Khorafi, if that's the case, or I have been informed by Mr. al-Khorafi and Mrs. al-Hamed, whose name it was, if that's the case. And he can then go on to say, and should say, I am informed by Grant Thornton, naming the person, that they have done this work, or they have done the work in Mr. al-Khorafi's affidavit. That enables the defendants, if they're minded to do so, to serve a hearsay notice on you. Say that if you want to rely on those, you've got to produce Mr. al-Khorafi, and you've got to produce Mr. Grant Thornton. And they may say, and you've got to produce some documents. Well, now, the response to the first limb of that is, yes, we're happy to produce Mr. al-Khorafi, if that's the case, and this is what he will say, look at the affidavit that he's filed. And the response to the second, if you are so minded, is yes, we will produce the author of the Grant Thornton report, or whichever one it is that you're relying on. And the defendants could then ask questions, if they want to, of the author of that report.
My Lord, yes. Perhaps another way through is that my Lord does treat our application as embracing Khorafi 6 and all the exhibits, including the Grant Thornton report and its appendices, and then if my Lord gives permission in relation to that, that evidence is then in, and then they can deal with it from the horse's mouth, as it were.
Well, I'll hear what Mr. Brindle has to say about it, but the upshot would be that you could be required to produce Mr. Khorafi.
My Lord, yes, yes. And that follows from the fact that we're seeking to put evidence in from him.
And at the moment, it seems to me that you also ought to be required to produce somebody from Grant Thornton to say, yes, this is the material, and this is what we did to satisfy ourselves that it was genuine.
Well, that may be. We'll have to see what points are really taken. I would rather hope that sort of point won't be taken. For example, they've got their own KPMG reports, and we certainly won't be suggesting that they aren't the KPMG reports. And I hope
this is not litigation which is to be conducted on the basis of hope.
Well, the point we have taken is that these statements are, in our view, selective. Not that they're forgeries, but that they are apparently selective.
Well, we'll see if that
can agree what he wishes to agree and point out the deficiencies that he wishes to rely on.
My Lord, yes.
Is that the sum of your application?
Essentially, my Lord, I do need to just say why the application is, why the evidence, but why we seek to put it in now. In relation to the ABK material, obviously the key document we rely on does of course post-date the trial, and we didn't have the ABK statements and still don't have the ABK statements that would allow us to do the same calculation as we've done by reference to the certificate. We have to candidly accept that in relation to the CBK position, this is material that could have been made available at trial, and the point could have been made available at trial, and Homer nodded, as it were, it didn't happen. But in my submission, there's no prejudice to allowing this material in now. It is sui generis with the other material, with the ABK lending.
Well, what I don't think I knew at the trial, because I don't think anybody told me, that the ABK indebtedness had been refinanced by a loan from CBK.
My Lord, I can't recall whether it came up.
I don't think I knew.
I'm quite sure your Lordship was not told that.
Well, I certainly don't have any recollection that you were.
And the your short point is that actually that is something arising out of the relationship with ABK,
My Lord, yes.
which you now ought to be able to run.
Exactly, my Lord, yes.
And perhaps it could be said that if there hadn't been refinancing by ABK, you would still, the effect would be that there would be a larger claim to interest in relation to the. If there hadn't been refinancing by CBK, there would be a larger claim to interest charged by ABK.
Exactly, my Lord. So in a sense, the defendants will get a windfall if we're not able to produce this, I would submit. Well, I don't know if that was a convenient point to
They're no worse off
exactly.
having to meet the claim to interest charged by CBK than they would be having to meet a claim for interest charged by ABK if the refinancing hadn't happened.
Exactly, and that's why we say no prejudice. Great. I'm grateful, my Lord.
Thank you. Yes, Mr. Bond.
Well, Lord, there is a massive danger of matters spinning totally out of control here. The Lordship, at the previous hearing in October, not to take you back to...
Are you telling me that?
Sorry, Lord?
You're telling me that I'm losing control.
No, I think there's a
I've
danger.
been trying to
Sure, Your
exercise
Lordship
some without much success.
I'm appealing to Your Lordship not to allow that. But there's a danger. My learned friend's approach would certainly allow it to spin out of control. My Lord, Your Lordship was very...
That's why I've indicated that in relation to his application to use further evidence, and this is without prejudging your application, there shouldn't be any evidence at all. His application to reduce further evidence is to put in the Ministry of Justice certificate, which at the moment seems to me to be a post-trial document. I mean, what good it does him is a matter for argument, but it is a post-trial document. And as far as the refinancing goes, I would be minded to require him to file a proper witness statement by Mr. Al-Shamji explaining the source of his information. And you can serve a hearsay notice or treat a hearsay notice as served, which means you'll get Mr. Al-Khorafi and you've got his evidence anyway.
And then he'll have to give evidence and there'll be cross-examination and the matter will spin out of control. Lord, what I'm appealing to Your Lordship to do is to take the same approach that Your Lordship took in the October hearing, namely that any further evidence should be very limited indeed. I take Your Lordship's point about the hearsay notice, and obviously that is progress, I accept, but it's still, in my submission, the wrong approach. They should be limited to updating the ABK interest, which is what Your Lordship had in mind, plus, of course, they had the right, and they have the right, which they're exercising today, to come and ask for more. But Your Lordship should, in my submission, reject that suggestion that they should have any more than that. Your Lordship...
Well, the refinancing of the ABK indebtedness should be capable of being demonstrated, if at all, by one or two documents.
Well, apparently there was this refinancing. It happened before the trial was over. We were not told about it. Why were we not told about it? Why was it not put forward? It's a different head of claim. It's based on something new. Your Lordship knows that the point that you saw a lot of force in at the last hearing was that this is not a case where Your Lordship ordered a split trial. It's a case where the claimant should have put forward their case in full at the main hearing, subject only to one particular point Your Lordship made, which is that obviously events occurring after the trial were different. But here is a classic example of something that didn't happen after the trial. Indeed, if not suggested that it did, namely the CBK intervention. So what is the justification for allowing them to get away with now bringing a claim which they could and should have brought at the trial? My Lord, the answer is, in my submission, there isn't any. Your Lordship says, well, it can all be dealt with and they can prove it, but why should we be in that position? Can I remind Your Lordship probably remembers in which case I won't do it, it was going to be tiresome, but the way Your Lordship did see the matter back in October, because it wasn't in our submission a case that Your Lordship was saying, well, provided it's something to do with ABK, that's all right. That's not Your Lordship's approach.
Well, you better take me to the reasons I gave.
Yes.
Can
I do that?
Reasons I gave. The best place to start.
We have it in tab 36, but we also may have it somewhere else, but that's certainly where I had it, in bundle 12. And my learned friend has taken you to, he relies particularly on paragraph 3b2, and the reference to the first defendant's liability being assessed in relation to losses arising out of the claimant's relationship with Ali Bank, ABK. And learned friend suggests, and one could see if that was simply the only material that one was looking at, that effectively allows him, provided he can show some sort of connection with ABK, to show that that is something that he can bring in. But I respectfully submit that Your Lordship didn't intend anything as wide as that. And when we look at what you say in paragraph 8 in relation to evidence, it is pretty clear that Your Lordship is not imagining it as wide as that, but had firmly in mind the timing point, and that's paragraph 8 as illustrated by Your Lordship's reasoning at paragraph 9 of the Schedule of Reasons. And there you record that there's force in the defendant's submission. This is not a case where the court was asked to order or did order a split trial, and that's obviously a point that we make very, very firmly and make it again today. The evidence on which the claimants are entitled to rely for the purposes of setting the quantum of their claims.
The fact that you made it very, very firmly last time is recorded in paragraph 9.
Yes, indeed. But I make it again now, my Lord. I make it in answer.
In case I forgot.
I make it, well, Your Lordship made the point about CBK. CBK is an exact example of this. This was something where there is absolutely no reason why the court wasn't told that before. We now have to investigate something new that we didn't know about, but is not post-trial fact.
Well,
the Lordship says we don't suffer any prejudice, but we do because we're facing a new claim not brought forward at the trial, which is exactly within Your Lordship's reasoning with respect.
Well, if you read the whole of paragraph 9,
yes,
you come to the passage which says, I leave open the possibility
yes,
there may be some further matters
indeed
which justice requires the court to consider.
Yes, sir.
And if there is, the claimants may apply in writing to rely on evidence
Indeed.
of those matters.
Certainly.
And the point you have to address, I think, is this, that the claim in relation to ABK interest is less than it would be if the CBK refinancing hadn't happened. And so I may have to ask myself, given that you get a benefit because the CBK refinancing happened, should I admit evidence of that?
Yes,
because otherwise you get a windfall.
My answer to that is it would be entirely unfair for us to be required to deal with that, because it's not, what Your Lordship had in mind, I submit, in that sentence, was that there may be some case where somehow the claimant can come along and say, well, look, justice requires us to be able to put forward something which we possibly could or should have put forward before. No excuse is actually given at all by the claimant as to why they didn't put this forward before. And in my submission, the argument about the windfall is simply not a sufficient argument to get around the claimant's difficulty. Your Lordship is, if taking that approach, in my submission, taking a different approach from that which you envisaged back in October, and allowing a much more liberal approach on the part of the claimants than Your Lordship had in mind there. Why didn't they tell us about CBK? We're now told about it. We have to investigate it. Someone will have to be cross-examined about it, probably Mr. Khorafi. The experts, or if they are experts, will then have some figures which they'll have to deal with, and this matter will all take up a great deal of time. But at the end of the day, I think my position is, in a sense, and I don't apologise for putting it this way, it is a pleading point in this sense that we do say that this case, and this is the point Your Lordship, I think, saw force in before, that there is no good reason why they shouldn't be stuck with their pleadings. They haven't amended, even now, my Lord, to say, oh well, here's another head of claim, money pursuant to the CBK restructuring. They haven't done that. If they did, it would be opposed, but they haven't even done it.
No, Mr. Prindle, I fully understand that you're entitled to say, I've picked up an uncovenanted windfall and I'm jolly well not going to let go of it if I don't have to.
Well,
I've got that.
You can look at it that way, but I look at it in a totally different way, that I shouldn't have to deal with something unpleaded, which could and should have been pleaded earlier, in a case where there was no split trial, and Your Lordship envisaged in October that really, subject of course to some possible situation which may require injustice, the claimant to be allowed to advance. And of course, sensibly, your Lordship allowed for such possibilities, because there are always possibilities that something might come up of that nature. What your Lordship should not, in my respect, submission do is to say, oh, well, we'll allow them to get away with it, and in a sense, that will prevent the defendants from a windfall. It's not a windfall, my Lord, to be allowed not to deal with something which was not pleaded and should have been pleaded. So well, that is my fundamental point. Now, it may assist if I go to my learned friend's schedule because I think we're pretty well agreed what's an issue and what isn't. Is it helpful just to do that briefly, my Lord? I agree with my learned friend that, in a sense, my application is to some extent the converse of his, because we say in relation to the matters where he has put in evidence and we seek to strike him out, that is because they are not truly matters relating to post-trial events at all. And we say they put them in the wrong category. And in fact, similar arguments go to my application as go to my resistance to his. But I think as far as the categories are concerned, can I just run through them? Because broadly, we are agreed, and it is, I think, a helpful document. We're agreed that under Head A, there is nothing to be argued about. Under Head B, just to be completely clear about this, my learned friend is right that for today's purposes, there is nothing to be argued about under B, for the reasons he gives. However, I should make it clear, and I think it's made clear in our skeleton, that although for today's purposes there's nothing to be argued about, we have made the point and still maintain the objection that this is not pleaded, and will make that point at the quantum hearing. But for present purposes today, about new evidence going forward, learned friend is right. Lordship needn't trouble with it. It's not gone in that respect. Now, helpfully, my learned friend has broken down C into 4 elements. And he's right that C1 is not a matter which need concern us. He's split out, again helpfully, and I think this had caused some confusion, C2 from C3. C3 being post-trial interest without any complication, so to speak, straightforward post-trial ABK interest. Now he says that's objected to. I haven't consciously thought that I was objecting to that myself as distinct from C2. The C2 and C3 were run together. And unless someone tugs my gown and tells me otherwise, I don't maintain any objection to C3, because that is the very thing which your Lordship had in mind at the October hearing as being something that would be allowed. That's the 1.5 million genuine, straightforward post-trial ABK interest. So as I say, unless someone tells me I've got that wrong, that having been split out from C2, I don't think there's any issue about that. C2 is then the question of the interest between 2009 and trial, which learned friend has dealt with, and I'll deal with that. That's part of his application because it's undoubtedly a pre-trial matter. And we say that shouldn't be allowed to go ahead for reasons I will give in terms of any evidence at the quantum hearing, and that's on his application, and I'll develop that. The other matter that arises under C is C4. That is something he hasn't said very much about, but we certainly object to that. We say that's a new claim. It's been put in under the guise of not being a new claim, and it's therefore part of our strikeout application. We say this is a new claim, it shouldn't be allowed, certainly any evidence in relation to it shouldn't be allowed, and I'll come back and explain that a little bit further on.
Well, he says that that's not part of his application.
No, it isn't. He's right about that. It's part of our application to strike out, because we say that although it's been introduced in Mr. Al-Shamsi's first witness statement, and therefore is not subject to the application that my learned friend makes, we say it's a wrongful introduction of something for which he does in fact need permission, although he hasn't sought it.
Well, that's something you can take at the quantum hearing, or you can take it in your application to strike out.
Yes, it's the evidence. It's the evidence of it that concerns me.
Conscious of your encouragement not to let matters spiral out, I would actually like to deal with the applications that I've got in front of me, and I'd like to finish dealing first with Mr.
Yes. Now, I was just going through to tell your lordship which category they fall under, but that falls into my application rather than his application. And then D is, as he's dealt with this to some quite a full extent, I would, that obviously is something that falls under his application, and he's dealt with it, and I'll oppose that. That's D. E he hasn't said much about, because that's something which falls under my application, where we again say that although no leave has been sought, leave ought to have been sought, because this is essentially, in nearly all aspects, a pre-trial matter, and permission should have been sought and hasn't. So that's the overview.
But this, well, we'll come to that when we make your application. But this sale happened after trial, didn't it?
Well, the actual sale did, but all the facts except the actual sale took place before trial. Can I just show you, Lordship, Mr.
Well, you come to that when you come to your application.
Yes, I'll come to that later.
At the moment, dealing with his application, the 2 points that I think I need to decide is, first of all, whether he should be allowed to tender in evidence the Kuwait Ministry of Justice document, subject to whatever steps he needs to take to prove that that's what it really is.
Yes.
Leaving you at the contrary determination to argue if you want to, but it doesn't take him anywhere. And the second is whether he should be allowed to introduce the evidence of what the CBK interest was. And that turns on the question, I think, as to whether I'm persuaded that although it could have been and probably should have been raised at the trial, justice requires that it be dealt with if I'm going to deal with ABK interest, because the two are related. I say the two are related because at the moment my understanding is that if the CBK refinancing hadn't happened, the claim to ABK interest would have been greater.
Well, that's what they allege, Lord. I don't think your Lordship can assume that that's the case, but that's certainly what they allege.
Yeah.
But it's at the moment uninvestigated.
Well, it's not
may
rocket
turn out to be
science.
true.
It's not rocket science. If I am indebted for what in my world would be a large sum of money, like £100,000 to Bank A, and I borrow £50,000 from Bank B to pay off Bank A, the interest charges to Bank A are reduced because I've incurred parallel interest charges to Bank B. The interest charges to Bank B may be a bit more or a bit less than what I would have been paying to Bank A, but that depends upon what the rates are.
Yes. Oh, I see that as a theory. My concern, obviously, and your Lordship's concern, is evidence. What evidence is going to be allowed in? How much is one going to risk loss of control? Now, to put
it seems to me at the moment, and this is intended to be of assistance, it seems to me that if they want to rely on the fact that refinancing happened, you must have an indication of where that information comes from, and you must have the opportunity to challenge it. So that you must have the opportunity, if you want it.
That must in part come from Mr. Al-Khorafi himself. That must in part come from Mr. Al-Khorafi himself.
And so if you want it.
And the learned friend is saying, I think, and I understand it, that one way or another, he does want to put forward Mr. Al-Khorafi.
Yes. Well, it seems to me you're entitled to have Mr. Al-Khorafi as a witness, whom you can cross-examine. On this narrow point, was there a refinancing? You may be entitled to have Mrs. Al-Hamad for what benefit that will give you, if you want it.
My other real concern,
but it doesn't seem to me at the moment that's actually going to take very long.
Well, that may be the case. I don't know, on that point alone. But perhaps my greater concern is Grant Thornton. Now, the Grant Thornton position is really quite extraordinary. Your Lordship was given at trial a report, if it was a report, by somebody called Griffin. And you remember there was a debate about whether that was expert evidence or not. But for reasons which are, to me, obscure, the Griffin have now a strange correlation with Grant Thornton. Griffin are still on the scene, and Grant Thornton are also on the scene. And Grant Thornton have put in a report which they say is an expert report. They say they are experts. I can show you that if necessary, but that's what they say they are. And they were asked to do, effectively, an expert appraisal, which goes into all sorts of aspects of this case.
Well, am I bound by what Grant Thornton thinks they do?
Well, if they think
and
that...
I'm sure Grant Thornton are experts in all sorts of things, including possibly adding up figures.
It's not only... Well, I think what really we're well beyond the question of simply adding up figures. One can see this from KPMG's answer to Griffin, and answer so far as they can give it, to Grant Thornton so far. The parties do not agree. It's not that they have a different view about whether 1 + 1 = 2, which on the whole they don't. One would be surprised if they did. But it's a question of what figures are you adding up? What is the material, and what is the reliable material? We have bank statements which are incomplete, and in respect of which Grant Thornton speculate about how the position may have been during the period where there wasn't a bank statement. And KPMG have a different view, and one looks at, even on the areas where there's no dispute as to admissibility of evidence, so to speak, the issues at B, for instance, where the matter is definitely going to the hearing, they come to a different view. It's not because they have a different concept of mathematics, it's because it isn't simply a question of adding up figures. It's a question of taking materials, taking alleged evidence that supposedly supports the payment of interest or whatever, and coming to a calculation. Well, your Lordship will be familiar with the fact that experts often do give evidence at trials in relation to quantum, and they're not just adding up figures, they're doing much more than that. Anyway, that's in a sense a slight diversion. My concern is to get rid of the Grant Thornton report, and you'd be absolutely clear about it. Now, to an extent, Malone Trent has helped me there, because the position put forward in November when they put their evidence in the first place has been quite revolutionised in a way I didn't trouble the court with, by the way they put the matter in January, when they've come up with different figures in a number of cases, this time calculated by Griffins, not by Grant Thornton. And frankly, it seems to me that the whole of the Grant Thornton report is unjustified as being something that we should have to deal with at the quantum determination. I'll come to Griffins later, because I accept that to a large extent your Lordship has accepted that however one classifies it, that material should be before the court, and they have supplemented that. Can I show you what we say we're actually asking the court to do, which is in our skeleton at paragraph 39 and following? May just help, and then I'll come back. Because although your Lordship may think we're trying to get rid of everything, it isn't as extreme a position as that. What we say, firstly, if you look at paragraph 40, this has some similarity, but not quite the same as what the Lordship was suggesting, but somehow or other, they should first of all list what actual contemporaneous documents they're seeking to rely on. This is rather similar to your Lordship's suggestion that in relation to the certificate from the Ministry, that should be, in a sense, specified in the way that so the actual documents they're relying on, as opposed to expert or quasi-expert reports and the like, should actually be listed. Your Lordship may have a slightly different view of that. It's not a million miles away from what we're suggesting.
Well, the view I take is that, on the whole, documents don't prove themselves.
Yes.
I mean, there are some that do, like a court order or an act of parliament, but on the whole, documents don't prove themselves. And if they want to rely on bank statements, you can either agree that, yes, these are bank statements, or you can say, yes, these documents are bank statements, but they're not all bank statements, Or you can say, I don't believe they don't accept those bank statements at all.
Or we can say, my lord, those are an inadequate selection of bank statements. Where are the others? Will you please disclose them?
Yes, well then you can ask for that, but
which is certainly what we would do.
What they are entitled to put before the court and prove, as it seems to me, are the documents on which they want to rely. And if those are bank statements, then if you don't challenge that they are in fact copies of bank statements, it's not necessary to call somebody from the bank to say yes, they're bank statements.
Right.
But if they put those in and you say, I see what these documents show, but they don't show enough to enable the court to reach a conclusion, that seems to be at the moment we had for argument.
Yes, but it does involve a good deal of further activity between now and the quantum hearing. I mean, at some stage later today we'll perhaps come to when we're going to have this quantum hearing. But if it were to be still sometime in that third week of February, which is currently due to be, have we really got time to go through this process of them serving, us objecting, further requests for disclosure, and all of that we got out of the way, one wonders. And fundamentally, my lord, your lordship wasn't expecting anything like this when we were discussing these matters in October. You thought it was a simple matter of basically updating the ABK interest. Yes, of course, as you've pointed out to me, my lord, and I accept this, you did make a reservation.
I don't think I knew about CBK.
No, you didn't know about CBK.
So, not expecting it, I don't think I knew about CBK.
No, but your lordship was accepting broadly, or not finally, but showing sympathy with our essential submission that nothing new should be allowed.
What I did expect in relation to ABK was that somebody would need to crawl through the bank statements and identify what the interest charges were.
Yes.
That's what I did expect.
Yes, well, that's issue which that's issue C3, my lord. And that's post-trial interest. Yes, you did.
What I'm finding difficult in following at the moment is why crawling through the CBK bank statements and identifying what's interest is different in kind from the exercise of crawling through the ABK bank statements and discovering what's interest.
Well, maybe not. I think we have 2 or 3 pages so far of CBK bank statements. They're obviously inadequate. Obviously inadequate. The ones from ABK are inadequate as well, we say. But the other problem that's pointed out to me is this, my lord, in relation to this, that the documents which are relied on by the claimants are annexed to the Grant Thornton and Griffin reports. They've not been annexed into witness statements for a witness of fact.
They're exhibited to Mr. Khorafi's witness statement.
Take that point.
It certainly comes at you from both sides, Mr. Berry.
Sorry. Yes, well, I think some of them are. No offence, right, in respect to some of them, but some of them are exhibited to Grant Thornton. And I mean, we obviously want to be. If any point is going to come in, which is, we say, an illegitimate and unpleaded point, but if it's going to come in, we obviously want to cross-examine somebody about it. And the way it's been put through expert reports of Grant Thornton and Griffin, who themselves are supposedly not experts and therefore aren't going to be cross-examined, I mean, just prevents us from getting at the truth. And if we can get at the truth, then we are looking at a much longer and much more involved hearing than your lordship envisaged.
I think that's not quite accurately put. I've no doubt that both Grant Thornton and Griffins are expert in all sorts of things. The relevant question is whether this evidence is expert evidence for the purposes of this application. I'm not letting in it. I'm not minded to allow expert evidence in at this stage.
Well, Lord, in our submission, this is
expert
going to cause...
in the sense of opinion evidence.
Well, I have to submit, I think this is going to lead to trouble. The quantum determination, because Your Lordship will have said, right, I'm not allowed any expert evidence in. You'll be faced with not only the Griffin document, but the Grant Thornton document, which he says it's experts, but Your Lordship says you're not bound by that, all right, so be it. And how are we going to deal with it? Because how can it not be in a sense expert evidence for? Because these people don't know the facts. They didn't pay the interest. Grant Thornton didn't pay the interest, didn't receive a bank statement or pay any interest. All they can do is look at documents that other people have found, say, well, if you put these together in a particular way and extrapolate from the documents you don't have, you end up with a result. Now that is, in my submission, some form of expert determination. Since they don't have the facts, what else could it be? But I'm not seeking to exclude the Griffin report on this basis, because I accept that the court has already said that it would proceed on the basis of that. Although we don't accept this, we accept that from the Lordship's point of view going forward to the hearing, you should have that Griffin report as you said you would, effectively. My friend would no doubt make that point. We say it's expert report, well, never mind whether it's expert report, that's in a sense water under the bridge. We can't change that. And that's why I wanted to take Your Lordship to paragraphs 40 and 41 of our skeleton. Having made the point in 40, we say that the additional material that the court should have should be, yes, the Griffin report, the second KPMG report, which is our answer. I wouldn't say it's expert or not, but it's certainly, they take issue with Griffins. They say Griffins have not done the right exercise and have not produced the right answer. That's in the bundles, but I don't want to take it.
Just testing that.
Surely we should be at least allowed to do that.
You've got the second KPMG report.
Yes, that only deals with the matters that we're accepting that we have to deal with.
Yeah, but you can make whatever criticisms of the Griffin document that you want to make. And of course, you can make those criticisms on the basis and with the assistance of what KPMG have told you. But are you inviting me to treat the criticisms as having additional weight because they come from KPMG?
Well,
and if so, why?
I have this difficult. I think what sauce for the goose must be sauce for the gander. I mean, if they are putting forward Griffins as saying that that is something that Your Lordship should take account of, then I say Your Lordship should give at least equal weight. We're not saying more weight to KPMG. Not saying because they're KPMG they're better than Griffins or anything like that.
No, I'm looking at a document which tells me what has been done.
Yes.
And I may have to decide whether what has been done is a helpful or an unhelpful exercise. Why should I be looking at KPMG to tell me that?
Just to be clear for my learned friend, I'm on exactly the same page of this as my Lord. We are not saying Griffins or Grant Thornton has some special status that usurps my Lord's function.
Well, I find that extraordinary in the case of Grant Thornton. When they, I mean, shall I show you, Lordship, what they say?
He hasn't said anything about Grant Thornton. He's talking about Griffin at the moment.
Well, my learned friend's intervention, threw me off there.
The only Grant Thornton report that I'm being asked to admit, I think, in under Mr. Al-Shamji's affidavit, is one which they don't rely on. Well, maybe they do rely on one in relation to CBK, but they don't rely on the one that they refer to in that.
If that's the case, it should be binned. If that's the case, it should be binned.
Yeah.
But my Lord, they don't. See, what they do is, in Mr. Al-Shambi's first witness statement, where he introduces what we say are new claims, but they say they aren't, the whole of the Grant Thornton report is exhibited. And that's still relied on. And they say they can go ahead and do that. I'm straying onto my application now. The Grant Thornton report comes in right there with the Al-Shambi first witness statement, in support of all sorts of claims. As an expert, say Grant Thornton. They say that. That was their understanding of their instruction. I can show you the Lordship if necessary. I don't think the Lordship needs to see it. But they do say that. And if the position is that they don't really need Grant Thornton because they've got Griffins, then let's forget about Grant Thornton.
I mean, I don't take the view that I have to believe everything that experts tell me.
Well, the one exception to that may be if they say they're experts, and they say they've been asked to produce an expert report.
But that doesn't. I have to look at what function they're performing.
Well,
And if they're offering me opinion evidence, then I'm not letting it in.
It is a form of opinion, my lord. It's an opinion on whether or not certain materials do or do not support a claim for a certain sum. That's an opinion. They, as experts, accountants, as skilled accountants, let's say, skilled and experienced accountants dealing with figures and dealing with proving claims and what documents do or do not prove claims, they have a special skill. Well, this is, I would submit, quite normal. But anyway, I'm in a sense trying to look at this more practically and say, all right, in a sense, I'm not using this argument to get rid of the Griffin report, although I could if I was right, but I'm not. I'm trying to be realistic about that. But we have since then had this overlaid with what is in many ways a totally contradictory Grant Thornton report. And if I just take your lordship back to paragraph 8 of our skeleton, you can just see at a glance there how contradictory this is. So if I look at item 8.2, which is in a sense one of the uncontroversial areas of the case in terms of what further evidence your lordship allows, Grant Thornton dipped into that in their 20th November 2014 report, but that's been abandoned now, and they rely on the Griffin report, the original Griffin report instead. Now that's easier because Grant Thornton has certainly withdrawn from the fray on that one, but look at the others. If we look at 8.3, which is this total item C that my learned friend has broken down helpfully, on the 20th of November they put forward an analysis which seems to have been abandoned in favour of Griffins again. I may have misunderstood this, but my learned friend is still seeking to hang on in some way to the Grant Thornton report. I can't really understand why he needs the Grant Thornton report. And if only he would say he doesn't, then I think we'd make quite a lot of progress. The same is the case under E, where your lordship sees the bold text. And also 8.5, D, etc. So we have a most extraordinary overlap and confusion between these two reports. If you could only get Grant Thornton out of the picture, life would become a great deal easier. Now, Lord, still on my learned friend's application, can I deal now with some rather different points in relation to why your lordship should not allow the...
If you're just moving on, I think we'll take a 5-minute
yes.
break. 5 minutes.
All rise.
Yes, Mr. Mayor.
Well, trying to deal with this as economically as possible, can I now turn to the ABK interest between 2009 and 2013, which is item C2 in the schedule. Now,
Are we now on to your application?
no, we're still on my own friend application. This is something he accepts. He needs, because this is pre-trial.
Yes, well, the only evidence he wants at the moment, it seems to me, it's this bank statement, it's this Ministry of Justice document.
Well, if that's all your Lordship is going to allow him, then I would say no more. But he also wants...
I thought it was all he was asking for. Let's go back and have a look at the Shamshi affidavit.
He also wants various bits from reports, expert reports. If all he's going to get on that, literally nothing other than the document from the Ministry, then I suppose there's nothing else I need to say. But I can't believe he's content just to leave it with that.
Well, let's just have a look at what the Shamshi document says. Which of your bundles is Shamshi 2 here?
Oh, it's in bundle 1, I think.
I thought you say 2, I can't find it.
Tab 3.
You say, yeah. The problem is I haven't got it in tab 8.
No, it is in fact in bundle 3, Lord.
Yeah.
Tab 8.
Tab 8 in bundle 3. Yeah. Well, it's 789, isn't it? 7 is the Ministry of Justice report.
Yes, and then there's 8 and 9 as well.
Well, 8 just tells you how much they're claiming.
9, claim for interest is addressed in the draft Thornton report.
Yes, but he told me he wasn't relying on that. He was relying on some different document.
Well, what is he relying on and why should that be allowed? It's not, it doesn't seem to me that he's tying himself simply to reducing the ministerial certificate.
Well, the view I've taken at the moment...
If your Lordship is going to limit to that, I don't say more about it.
Well, the view I've taken at the moment is that I'm told that the report referred to in paragraph 9 is not being relied upon in relation to ABK interest.
But that's because something else is being relied on in each place.
Well, if so...
I'm not sure whether your Lordship is or is not being asked to, because this is their application, I'm still on their application, to allow anything or not, if there's nothing else.
Their application is to put in the Shamshi document, Shamshi witness statement. That's what they want.
Yes, but because he has this technique of referring to other things in here, if your Lordship had just allowed paragraph 9 in,
I haven't allowed anything in yet.
then that would have brought in the Grant Thornton report. Now they say they're not relying on Grant Thornton report, they're relying on something else. So that's still on the scene. Unless
Well,
if your Lordship is going to say
on something else, they have to make another application.
But if your Lordship is only going to allow in the ministerial certificate, then I will say no more about this head.
I'm asked
In terms
to
of
allow
new
in this witness statement, which, as you point out, should be in draft anyway. I'm asked to allow evidence in the form of this witness statement. And my present view, my present understanding is that the Grant Thornton report attached to the first witness statement is not the figure of 4,785,000.
Right.
Indeed, or perhaps indeed that figure at all. They may want to rely on something else.
Well, I'll leave it there. The other point, my lord, is the...
Do I take it you're not objecting to the Ministry of Justice document?
No, my lord. I'm
I mean, for what it's worth.
In the form that your lordship suggested, that it has to be approved by them, that it has to be... I mean, indeed, it's part of our paragraph 40 is that we suggested that any contemporaneous documents that they're referring to should be listed and served on that basis, not by reference to Mr. Al-Shamji's witness statement, and on a different basis altogether. We do have our pleading objection, of course, but your lordship may, provided your lordship doesn't reject that, you may leave that open until the quantum hearing. Certainly that's maintained, and it's maintained even with item B, which we're not arguing about today. Lord, as far as the claim D is concerned, this is the other part of Malone Fred's application. There isn't a lot more I want to say about that. I think I've been over the territory with your lordship. But there is one aspect that perhaps I should have made earlier, which is that, of course, the effect, and the learned friend said there's no prejudice to us, and indeed we're getting a windfall. The effect of holding back, as the claimants have done, the existence of the CBK refinancing has deprived the defendants of the opportunity to cross-examine Mr. Al-Khorafi in relation to that matter, in relation to liability. The lordship will recall that there was extensive cross-examination, particularly by Mr. Black, to a lesser extent by me, of Mr. Al-Khorafi about his assets and expertise, and the complexity and sophistication of his dealings. If we had known about the CBK matter, and indeed the other matter I'm going to come on to a little later on, the claim in relation to the tower in Kuwait, that would all have been matters which would have gone to, potentially, to liability. And that's another evil of allowing matters which could and should have been put forward at the trial now, for no good reason, to be put forward. And we strongly contend and invite your lordship not to allow them, unless there is very good reason to do so, to come up with things that they should have come up with before. And it would be quite unfair and wrong in principle to allow them so to do. And well, I think I've been over the subject matter of their application. Can I now turn, because it's all, as Malone Friend says, the arguments are actually quite similar in relation to our application. Is that convenient, my lord? Or?
Can I just be clear in my mind? If I were to require them to identify the source of Mr. Al-Shamsi's statement that they refinanced,
yes, yes,
the probability is that the answer would be Mr. Al-Khorafi.
Indeed.
It might be Mrs. Al-Hamad, but probably not.
Probably not. We've seen Mr. Al-Khorafi does himself already say something about it, so it's very likely.
If the answer is Mr. Al-Khorafi,
yeah,
then if a witness statement went in that form, you would be entitled to serve a hearsay notice, and the hearsay notice would say, effectively, you've got to call Mr. Al-Khorafi.
yes.
And they're perfectly content to do that,
yes.
And that would give you the opportunity to cross-examine him.
Yes.
Well, now, rather than go through all those hoops, I might be minded to say, well, I let in that paragraph on the basis that Mr. Al-Khorafi will be tendered for cross-examination on the evidence that he has put in. Now, would you have an objection to that?
Well, Lord,
Otherwise we can do it
I
for
certainly don't have any objection to it, in a sense, cutting out unnecessary
That's what I
formalities.
wanted to know. I mean,
To that extent, I do not object.
we
Obviously, I
don't,
have
we
a
don't
fundamental
need to go
objection.
through all
No.
the hoops. We can
No.
get there more quickly.
I think that in reality, this is all looking like it's going to be Mr. Khorafi who's going to have to make this good.
Well, he's going to have to, if he wants to satisfy the court that he refinanced the ABK loan, or Mrs. Al-Hamad refinanced the ABK loan, he's going to have to produce some documents which shows that.
We would say more than just documents, but
And himself.
yeah.
And
Yes.
then you can,
So, as a matter of mechanics, I don't take any technical points about that.
You
I
can
can,
if you
I
then
can see the
want to
force of it. But
put
my
to him.
objection is at a much more fundamental level.
you can put to him and you can put to me that the ability to refinance a bank loan shows a degree of financial sophistication which I should have been aware of when I gave judgment.
Yes, my lord, I would. And that is exactly why your lordship shouldn't reopen these matters. But as far as the technicalities of hearsay notices, yes. Well, very much the same point arises with what we haven't yet looked at all, but this is our application, Claim E, which is the matter that Mr. Khorafi deals with in his earlier witness statement. And can I take you back to that? Because we say that this should all be disallowed. The learned friend doesn't ask for permission, but we say he should have done, and had he done so, it would have been disallowed. The Lordship looks at the fourth witness statement of Mr. Khorafi. You'll see what this is all about, which is tab 9, which is bundle 3. That's just after where I think the Lordship last was. And you'll see that, contrary to what my learned friends submitted, nearly all of this story is pre-trial. And the existence of this loss was well known to and entirely within the knowledge of Mr. Khorafi before the trial. So, if your Lordship starts, you see some dates. So, paragraph 5 of this witness statement, the story starts in 2002. He purchased a plot of land and he intended to construct a tower on that, and then he mentions the fact that a particular company was introduced, which became a company called RAFCO, that's paragraph 6, which, and the land was transferred to RAFCO in 2006-2007, and then in order to fund the construction of the tower, ABK acted as lender. This is all long before trial. 2007, agreement was reached, and ABK was to provide funds, a loan to RAFCO for the purpose of developing the tower. We'll move on quite quickly, I think. Paragraph 11, as a result of the difficulties I have with the defendants, he explains, I won't read that, I'll invite your Lordship to read paragraph 11 to yourself quicker than I can read it out. Has your Lordship read that? Paragraph 11. Paragraph 12, interest payments fell due in July 2008. As a result, didn't have the liquidity to make the RAFCO loan repayments, that's till 2008. And then paragraph 15, November 2009, an execution file was opened in the Kuwaiti courts by ABK, so ABK are, as early as 2009, already effectively enforcing on this loan by seeking an order for the sale. Now, the sale didn't actually occur, so the 16th, paragraph 16, you have the 10th of January 2013, the courts ordered the land and partially constructed tower to be sold, and then it was only in 12th of June 2014 that the actual sale took place, and therefore the amount of the undervalue, if there was an undervalue, was known. Now, the position therefore is, we would submit, that at the time of the trial, it was well known to Mr. Khorafi that, first of all, on his view of the case, he had been forced through RAFCO to default on the payments to ABK, and that ABK had taken proceedings to sell, contrary to his wishes, RAFCO land, and that was all going through the court process. And therefore, subject only, we say, to the question of quantification of that loss, that was a head of loss which was well known to Mr. Khorafi at the time of the trial. Yes, he didn't know.
When do you say that the loss arose?
I think the loss was only finally crystallised at the time that the sale took place. But what I'm saying is, if you're looking at bringing claims against my clients for loss caused by their activities, it was known to Mr. Khorafi that because of our alleged, or indeed proven fault, in which it's found it proved, he had got into difficulties. He'd had to allow ABK to take enforcement proceedings against his property, RAFCO property. And one well knows that any forced sale is very likely to result in something less than market value being recovered. That's the nature of forced sales. Yes, he didn't know the exact amount, but what is the justification, I ask rhetorically, and I mean as a genuine point, what is the justification for not having brought any of this forward at the trial? And indeed, he was cross-examined about his relationship with RAFCO to some quite considerable extent by Mr. Black. But these facts were not known. And merely to say, aha, well, because the actual sale didn't take place till 2014, therefore I didn't know the amount of my loss until then, therefore I should now be able to bring this forward without even asking the court's permission to adduce any of this evidence, as a matter of right, so to speak, in the light of the way the hearing in October went and Your Lordship's observations at that hearing, is quite remarkable. And here, of course, one does have the scope for very considerable further evidence and inquiry. I think it is accepted by my learned friend that Mr. Khorafi would certainly have to give evidence about all of this, with or without any essay notices and technicalities. I don't think that point even arises particularly here.
Well, he would have to.
No, I don't think
he has given it.
He has, exactly. There's not a point.
And you can require him, if you don't persuade me to strike out his fourth witness statement, you can obviously require him to be tendered for cross-examination.
I can, and that would, again, greatly lengthen the process which the court has had in mind. It would be an unjustifiable extension of the pleaded case, which is quite wrong in principle, and Your Lordship should not allow it. Again, there's going to be, if it goes forward, there's going to be requests for further disclosure from us before the hearing, because although we've got the bare bones of the story, goodness knows what lies behind this. We've got, as we say in our skeleton argument, issues that are going to arise about remoteness of such claims. It's going to enormously complicate and lengthen the hearing. There's also issues of valuation are going to arise, because by the very nature of this claim, it's a sale at an undervalue. So who's going to prove that it was an undervalue?
Well, at the moment, Mr. Khorafi is going to say that it's an undervalue.
We will no doubt want to challenge that, or we will certainly want to investigate it. And so that will be asking a valuer if what his view is. They may say there's no undervalue at all. How is Your Lordship supposed to deal with this? That what was supposed to be a short, no more than 1 day quantum determination, currently fixed to take place the 3rd week of February. Now, it is true that at the October hearing, my learned friend did make some mention of this claim as being something he might seek to bring forward, to be fair, but that's a way short of a pleading. And well, we we seem to have moved so far from the pleadings now that it really is becoming a major problem. I do respect, it's this limit, that we are entitled to say that the claim should have been pleaded against us before we have to meet it. Here is a claim which isn't even now put forward by amendment. A sale at an undervalue. Even now, a learned friend isn't saying...
How do you say that they could have claimed this loss at trial? They hadn't suffered it.
It hadn't been quantified, but they could easily have done. They could have said...
Well, it's not just quantified. You don't suffer a loss until you have a sale at an undervalue.
Well, you do suffer a loss to the extent that you should certainly tell the court that it's one of your claims because your property, or the property of Rafco, it's not even his property, it's Rafco's property, has been taken from it by the bank under the order of the court. Okay, the sale hasn't happened, but the sale has been ordered, and that is very likely to cause a loss to be suffered. But not even now there's no amendment. So why should they be allowed, without even now amending their claim, to take forward to quantum determination this new point, which we have to investigate? This case, it's plainly a much more extensive inquiry than what may turn out to be a more limited point in relation to CBK, as the Lordship mentioned earlier. On the face of it, this looks like a much bigger and wider inquiry. And Lord, lastly, the remaining point...
I think I have to decide whether this is properly to be regarded as a claim which arises out of his relations with ABK.
No, because that's not a substitute for a pleading. That's not a substitute for a pleading. When your Lordship said that in the order, your Lordship was saying that was the scope of the quantum determination. But I don't accept your Lordship was saying that was some sort of implied amendment to a pleading to claim something that wasn't pleaded. So it's not pleaded. The pleading doesn't say any losses arising out of our relationship with ABK. It claims simply the interest that had to be paid to ABK. That's all it claims. Up to 2009. That's all it's claimed. And of course the principal amounts which your Lordship's already dealt with. My learned friend is wrong in my submission to construe your Lordship's order to say, well, this effectively allows complete carte blanche to bring in anything, provided it's got some connection, or rather, with ABK. That wasn't what your Lordship had in mind, I submit. Your Lordship obviously knows better what you had in mind than I do. My submission is it doesn't appear to be what your Lordship had in mind in October. It is in my submission wrong. Can I lastly deal with the remaining item of little c, which not much attention has been directed to, C4, going back to my learned friend's schedule. This is cost of funding cash introduced by claims. This is, and if I take your Lordship to how we deal with this in our skeleton, paragraph 30, and then paragraph 8.6. Paragraph 30 is dealing with both this matter, C4, and also E, the tower point, which I just dealt with. And in the interest of time, I just ask your Lordship to note what we say in paragraph 30 without reading it all out.
Where does this come from? You're asking me...
This is some further borrowing that they say...
You're asking me to strike out their evidence.
Yes.
Where in the evidence? Their evidence?
I think I can show you, Lordship, this. If you go back, I'm answering...
I can't find it under C4,
yeah.
which refers sufficiently to the...
It's referred to in our paragraph 8.6. So if I first of all take you to that and then take you to the material.
Paragraph 8.6.
Yes, and then I'll take you to what's in the Griffin report, which I think is what supports this.
And it's in our table on the third column. We have the evidential references to each head.
Thank you. Yes. Yes, absolutely. The learned friends answered. I'm going to take you there. It's in fact supplemental Griffin's report 6.4, as we say in our paragraph 8.6.
Where does this come in the evidence?
Yes, I was going to take you to that. Griffin's supplementary report, paragraph 6.4.
Where is that in the evidence?
Tab 14.
Who's trying to put in Griffin's supplemental report?
There.
In the evidence?
Oh yes. We've had the original Griffin. We've had 2 Grant Thorntons and 2 Griffiths. Oh yes, it's all there. We don't seem to put any of it in. Tab 14, page 1609.
Which bundle?
Tab 6. Bundle 6, thank you. Yes, now this supplemental Griffin report starts at the beginning of tab 14, if you want to got this bundle.
Now, this is Exhibit RAK5.
Correct.
To what?
To Mr. Khorafi's 5th witness statement, which is at the previous tab 13. So his 4th witness statement was the one dealing with the tower that we looked at. This was his 5th witness statement, because what happened was on the 8th of January, my lord, the claimants put in a whole load of new evidence beyond what they'd put forward in November, some of which contradicted what they put in November, in particular the relationship between Griffin supplementary and Grant Thornton. But
where is your... Can we just have a look at your application? Bundle 1, is it? And look, at the moment I'm dealing with your application, the 15th of December.
yes.
So it is at least unlikely that you would be referring to this evidence in that application.
Yes. I think at that time...
Well, just look at it. It's tab 3. Your application is to...
Yes.
They may not rely on the quantum evidence adduced and served on the 20th of November
Yes,
be
right.
excluded.
That was a Grant Thornton report. You can get the reference to that. The first Grant Thornton report, which has now been overtaken by this Griffin supplementary. But that was what we were attacking at the time, namely, and now I think abandoned, calculation by Grant Thornton.
But if it has been overtaken, you haven't caught up with it yet. I have no application in front of me at the moment, or if I have, I haven't identified it, or if I haven't identified it, you haven't identified it for me. I haven't got an application in front of me to strike out the 5th witness statement of Mr. Khorafi. Now, it may be the answer is that I don't need one because it wasn't filed in accordance with my order. It's too late.
Yes. I think it is, my lord. It was only filed on the 8th of January.
No, it was filed on the 7th.
7th, all right, 7th then.
Well, I directed, I think, that they be filed by the 20th of November, didn't I?
Yes.
Well, this one is 3 weeks late on that. More than 3 weeks late, nearly 2 months, 6 weeks late.
Yes, well it is.
So how can they rely on this at all?
Well, I could take that point, but being as constructive as I can, let us assume that they can do that, which may be kind of them. Your Lordship, I don't think would be then criticising me for not having amended my application to attack something that they should never have put in. But the bottom line is they are relying on not the Grant Thornton figure, which was in any event a much lower figure, of only about 180,000, as
we say in our paragraph 8.6. They're not relying on that. They are relying on this, the Griffin's report, which is in fact only came in on the 7th of January. And it is interesting just to see what is said in support of this. The letter friend's reference in the schedule is the same. If your Lordship goes to tab 14 in bundle 6, paragraph 6.4, the page number at the bottom is 1609. The topic is settlement monies paid by ABK for C1 and C2 accounts, starting in paragraph 6. And then they say in 6.3, in the Griffin's report, that's the original Griffin's report, it was identified that the claimants had introduced net cash of 5.9 across all the ABK and Sarasin accounts. The Griffin's calculation to arrive at the net cash figure introduced takes into consideration cash introduced, cash drawn, cash transferred. This sum reflects the underlying nil transaction methodology, etc. And then 6.4 is the crucial paragraph. Although the sum of 5.9 million is reflected in the Griffin's report, total of costs and losses, the report did not calculate the cost of interest on that sum. If the claimants had resorted to borrowing those funds, we have been instructed to calculate the cost of funding using the LIBOR rate plus 2%. They've just been instructed to do it. I don't know why, on what basis. They've just been instructed to do it and have done it. We have previously identified that this rate was one of those used by ABK in contracts with the claimants, and therefore appears to us to be a reasonable base in which to calculate the cost of financing, and then they do so. Now,
well, the table does what the table purports to do what they say they're going to do.
yes.
I don't know whether you quarrel with the figures in the table or whether the quarrel is that they pretty have made an assumption that the right rate is LIBOR plus 2,
Well,
and that I'm stuck with it.
underlying all of this
You're
is the allegation that the claimants had to resort to borrowing. This is a further borrowing, which is certainly, again, a wholly unpleaded matter. It may have been tucked away as a general concept in the Griffin's first report.
Well, it may be unpleaded, but it's not actually said.
No.
6.4 doesn't say the claimants had resorted to borrowing.
No.
It says this is what would happen if they'd had
Yes.
done so.
So where's the evidence that they did?
Well, there isn't any, at least not there.
Well, looking at my learned friend's schedule, let's see what he says in his schedule, page 5 on the C4, in the right-hand column. No need to rely on evidence for this calculation. Losses of ABK lending still at large. This is an element that could have been made by way of submission. Defendants have advance notice of the case, but somebody's got to say, haven't they? We had to actually resort to further borrowing in order to
Well, if you tell them what they've got to say, I expect I'll soon be met with an application to put in an affidavit saying it, Mr. Brindle. But at the moment I'm dealing with your application,
Yes.
which actually doesn't cover striking out this affidavit, because it doesn't need to, because this affidavit can't go in without without needing.
Yes.
And they haven't applied to put it in. Is that not right?
I think it is right, Lord, yes, and perhaps I'll see what the learned friend says in response.
No, just to pick up on that one, that's not quite right. This is our affidavit. This is our witness saying we did reply. Our reply evidence, as per or put in accordance with the timetable. It's our substantive evidence, so it does go in, unless my learned friend applies to strike it out.
How can you put in a new claim by way of reply?
Well, Lord, that's a separate question. Whether this part of the evidence can be relied on at the quantum hearing if it's a new claim. Our big point, and I hesitate to interrupt my learned friend, but our big point is that this is a calculation.
Well, if it's a calculation, you don't need evidence.
No, but the consequence of that, Lord, is not that the whole of the witness statement goes, because the witness statement is reply evidence which deals with lots of, on any uncontroversial areas that Mr. Khorafi was entitled to deal with, like the tower and so on.
Well, yes, I don't think I was going. I don't think I did say that I was asking for the whole of Mr. Khorafi's witness statement to be excluded.
I don't think Mr. Brindle was, but I think they're bearing some cross purposes.
Whether I was. My concern here is that it is being assumed by the expert that extra borrowing was resorted to. And if I'm going to have to deal with that at the forthcoming hearing, I mean, what is the evidence of it? Is this something that can go forward, or should Lordship just cut it out? So it's just not a legitimate...
If there isn't any evidence of it, you can make that point of the quantum determination.
Well,
And you can't ask me to strike out something about which there isn't any evidence.
No, I see the force of that. I do see the force of that. But you should obviously understand I just trying to work out what it is that I have to deal with, and what we go away from here, what we have to take any further. I mean, the fundamental point we make, which, as you all should know, is that really nothing should be allowed to go ahead except for the updating of the ABK interest, item C3, which having been stripped out, we don't object to. We'll deal with item B, de beni esse, although we said that's not pleaded either, but that's not for today. And item C1 we'll deal with, and the rest we shouldn't have to deal with. And any evidence that's put forward to support it should be either not allowed in on their application or disallowed on ours. That is to simplify matters, but it's really well done. Now, can I just ask whether I need to deal with anything else? Lord, I think that's all I want to say. I think Mr. Black may want to say something short. Dependent on your Lordship's decision on these matters, there may need to be further consequential orders and directions to be made between now and the quantum hearing, but I'll leave that until later.
Well, you have an application, or there is an application in front of me. I think it's the 7th of January, is it? In which you want to raise...
There was a question about the hearing date, Lord, yes.
Hearing date.
Yes.
You want to leave that over for...
Well, I think so. Well, one reason for leaving it over, of course, as to what the length of that hearing is going to be in the light of your Lordship's decision today, that may be considerably longer than anybody has so far been thinking. But can I come to that later? It would be premature.
Well, this is a sort of implied threat, Mr. Brindle, isn't it? That if I don't agree with you on this application, I'm stuck with a 3-day quantum examination, which I've got to find a slot for. And I have recognised that point.
Well, yes, it is, and I suppose in a sense, but it's also, I mean, we would love to be not to have to go 3 days, to go for one. So it's not only a threat, it's also self-preservation as well. Lord, I don't think I have anything else to add at this stage.
Thank you. Well, let's invite Mr. Black if he can hear us. Mr. Black, you don't need to stand up if you don't want to. Sit yourself. Since it's about, this must be just about dawn with you at the moment. Is there anything you want to add to what you've heard from? Have you been able to hear the head of the argument? Thank you, Mr. Black. Is that all that you wish to say on these two applications? Thank you. Mr. Hill, I shall have to rise, I'm afraid, at 5 to 1.
Oh, yes.
I have a telephone link conference at 1 o'clock in relation to tribunal matter. So I can't sit past 1 o'clock or can't sit past 5 to 1 in order to complete this before lunch.
Oh, yes.
So it may be that we have to come back after the break anyway.
Yes.
But if you like, I mean, are you likely to finish in the next 15 minutes or?
I don't know. It's actually possible. It's hard to tell how long I'll take. Can I try?
Well,
and then if I don't, I'll certainly make
what I'm saying to you is that if you'd rather have a clean start at 2 o'clock, that's fine. But I'm not going to be able to do what I would normally expect to do, which would be to sit in order to finish your submissions before lunch. Well, I may not be able to do.
Well, Lord,
I don't want to rush it.
Just looking through, I would be rushing and I won't do it. So perhaps a clean start at 2 would, if that's acceptable for my lord, a clean start at 2 would be preferable.
Well, I think that's probably more sensible than you're trying to rush and me fidgeting. It's probably better if you come back at 2 o'clock.
Well, yes.
My intention would be to give a ruling on these matters tomorrow. I don't think I want to do it extempore this afternoon. I'd like to try and collect the thoughts together overnight. And for one reason or another, the convenient way for me would be to deliver a ruling tomorrow afternoon, because I have another application in the morning. I don't expect anybody to stay over for that purpose. You've all got juniors who can come and listen to the ruling. But if that produces difficulties, it would be helpful to know about them now.
My lord, I don't think there will be difficulties in that I'm due to be on a plane tonight, so
You're not going to be here tomorrow anyway.
I'm not going to be here tomorrow, but if it were necessary, I could try to see if arrangements could be made to change things.
Well, I'm not requiring it.
No, I'm grateful, my lord. What I also wonder is whether, if in the light of my lord's ruling, the parties could be given perhaps 24 hours to put any submissions in writing, rather than people try to react to the ruling and make further submissions for what happens on their feet. And then Mr. Brendan and I could have input, and then perhaps...
Sorry, submissions about what?
If there are further consequential steps, consequential on my lord's ruling and or costs.
Well, Mr. Brindle is asking for costs against you on an indemnity basis on this application, which you will probably want to respond to.
My lord, yes.
If he succeeds on his application.
Yes.
The other matter that I want to get resolved by the end of tomorrow, if possible, is the date for the quantum determination. Now, if the quantum determination happens on the 16th of February, as it is presently planned to, it can extend over, as far as the court's concerned, it can extend over 1, 2, or 3 days if necessary. If the parties want to come up with a subsequent date which is acceptable to both of them and to the court, then obviously I'll take notice of that. The reason why the matter is fixed for the 16th of February at the moment is because that is in fact the first available day after the 29th of January, and that's what I ordered.
Very quickly on that.
So, but if I heard it suggested that the parties could do dates at the beginning of March.
First, 2nd and 3rd of March are work for all the parties.
Well, the first is difficult. 2nd and 3rd are perfectly possible. I have a problem in my diary on the Saturday the 28th of February. So starting here on the 1st of March is difficult. But the 2nd and 3rd
would probably be
2nd, 3rd and 4th are perfectly
2nd,
right.
3rd and 4th.
Are perfectly right for me.
Yes.
We have, I'm told by the registry, we've let out the courtroom, but I dare say we can probably accommodate that problem somehow, either by breaking our contract with whoever we've let it to, or finding some other room to have it in.
My Lord, well, that would solve the problem, because I certainly oppose my learned friend's suggestion of moving it from the 16th to the 19th, but I wouldn't oppose moving it to the 2nd and 3rd, and I would support that.
Well, as far as the court's concerned, I'm anxious that this should happen sooner rather than later, because I don't want it drifting off into the summer.
My Lord, and there's one fact.
There's no point of principle which requires it to happen on the 16th of February rather than the 2nd of March if the parties are agreeable to that move, as far as I can see.
Well, I'm grateful, Lord, and in that case I think we're all agreed it should be the 2nd of March.
Yes, we are, Lord. Thank you very much for that.
And that has the advantage that I can then do it, whereas both the 16th and the 19th of February meant that I wouldn't have been able to do the hearing, and we would have had to instruct a new leader, so that helps.
Yes. Mr. Brunel, you could do the 2nd of March, could you?
Yes, indeed, Lord. I'm very pleased to hear that, because the parties had liaised and found that those were convenient, and I'm very grateful to the court for making those dates available. I appreciate that it may not be terribly convenient, but it's very convenient for us. I'm grateful.
Mr. Black, what about the 2nd, 3rd, and if necessary 4th of March? Is that possible for you? Right. And do you think you'd be able to get here in person? Well, I mean, 3 days is not 3 times worse than 1 day, I don't think. It's the length of continuous session that you have to, that causes a problem. But I've been quite encouraged that today's video link seems to work rather better than usual. And I hope that we may. Now, you're at the IDRC, are you? Yes, I see. Yeah, well, we seem to be getting. I thought you were in Chambers, and I wondered if you'd sold all your books. But obviously, it's not as bad as that. The IDRC can cope with a 6 o'clock start in it. Well, obviously, it did today. Well, that may avoid the need for a debate about dates if we can go for the 2nd, 3rd, and 4th of March.
And on that basis, if it is going to be tomorrow afternoon, I would invite my Lord to dispose of what my Lord can in the judgment, and then perhaps we could have 24 hours to put in any submissions that are necessary for post-judgment directions.
Yes. Well, I would certainly hope to dispose of the 2 applications that are in front of me in a ruling tomorrow afternoon. And Mr. Brindle, I wouldn't expect you to stay over for that purpose.
No, Lord, but I would I join in my own friend. I think it may be that we would need a little bit of time after the ruling to consider what, if anything, might be necessary by way of further directions between then and the 2nd of March. We'll need a bit of thought. Or might do, depending on which way your lordship goes. I think we'll only accept.
So what you want is something in the form of an order which says subject to further representations or something of that nature.
Well, yes, that caveat would be useful.
Very well. Well, we'll come back at 2 o'clock,
Oh, yes.
and you'll then complete your reply on your application, and Mr. Brindle and Mr. Black, if he wishes to join in, strictly, I think, will have a right to reply on your application, Mr. Black.
May seek to exercise that right.
Okay.
All right.
Thank you. 2 o'clock.